Well, good morning, everyone, and welcome back to another blockbuster Radcliffe Chambers Junior Programme series. I am Matt Mills, and joining me in the commentary box is Emma Loizou. Please note this session will be recorded and put up on our YouTube channel, so you can watch it again and again if once just isn't enough. We propose to split this webinar into three parts. Firstly, Emma will talk to you about the government's recent proposals for executing wills virtually. Secondly, I'll then discuss a few important practical tips about administering estates. And then thirdly, we'll take any questions you have. Without further ado, I'll hand over to Emma.
Thanks, Matt. Hi, good morning, everyone. Today I'm going to be speaking about wills, giving an update. In particular, I'm going to be talking about the government's new proposal and the recent legislation that's been laid before Parliament this week to allow electronic witnessing of wills. So just to start off at the outset with where are we now, really? Well, on the 25th of July 2020, there was the government announcement that it was going to be introducing legislation to allow individuals to witness wills electronically. That announcement was coupled with some guidance that was also published in advance of the legislation. And that government helped set out what the proposals would entail and assist the public and practitioners in advance of the legislation. The relevant legislation that's been laid before Parliament this week on the 7th of September 2020 is called the Wills Act 1837 Electronic Communications Amendment Coronavirus Order 2020. So quite a mouthful. I'm going to refer to it as the order, I think, for the rest of this presentation for ease. So that's this week, and it's due to come into force 21 days later, which is on the 28th of September 2020. So my talk today is going to focus on five things, really. It's going to look at the current requirements that we have at the moment in relation to witnessing wills. I'm then going to look at the new legislation, the order, as I've set out. And following that, I'm going to look at the government guidance that was published in advance. Following that, I'll look at some risks that will that have arisen with that proposal, and finally look at what's not changed, so what's still in place. So, starting with the current legislation, the legal formalities of making a will are established by the Wills Act 1837, namely Section 9. And that sets out what the testator must do. Subsection A, it's in writing, signed by the testator or by some other person in his presence and by his direction. B, it appears that the testator intended by his signature to give effect to the will. And then for our purposes, we have C and D. So C, the signature is made or acknowledged by the testator in the presence of two or more witnesses present at the same time. And D, each witness either attests and signs the will or acknowledges his signature in the presence of the testator, but not necessarily in the presence of any other witness. So that's what's needed for a will to be valid. And the formalities are essentially protective. They're there to protect testators from fraud, from undue influence. The explanatory memorandum to the new legislation indicates that the current requirements are likely to be interpreted as requiring the physical presence of the testator and witnesses for observing those formalities. And there's been no case law on video witnessing, remote witnessing in that respect. But clearly this act was made some considerable time ago, 1837, and would not have envisaged the use of technology that we have today. One requirement for the witnessing is that presence is usually determined with reference to whether there is this clear line of sight that the witnesses and the testator have, and that's a requirement under the existing law. Now, the government in its guidance has indicated that there are several scenarios that would lead to the will being properly executed under current legislation, and that's provided that the clear line of sight is maintained. So they've given three examples which are witnessing through a window or open door of a house or a vehicle, witnessing from a corridor or adjacent room into a room, and witnessing outdoors from a short distance, for example, a garden. So those examples are all quite helpful, I suppose, in this time of social distancing, because they allow for the 2-metre rule, for example, when witnessing wills. And there's quite an interesting case that also was decided a considerable time ago that I guess is used to support sort of social distancing witnessing of wills. And this was the case of Casson and Dade. It's a very, very brief judgment. It's found in the Brown's Chancery cases. And essentially, it was about a woman called Honora Jenkins, and she went to her lawyer's office to execute her will. But as she was asthmatic and the office was quite hot, she went to her carriage to execute the will, and the witnesses attended her there. After the witnesses attended to her execution, they then returned to the office. And Miss Jenkins' carriage was then put back so that the window of the carriage faced onto the window of the office, and she could then see through that window the witnesses attesting the will. And the Lord Chancellor held that he was satisfied the will there was validly executed. So that generally supports the proposition that a line of sight between the testator and witnesses is sufficient for there to be presence under Section 9. So that's the current law. So moving on to what's happened recently. So we have the Wills Act, the order, the 2020. So the first thing I guess I want to just look at is why this legislation's been introduced. And the government guidance has said that it aims to respond to the fact that during the pandemic, more people have been making wills during this time. And for some people who are self-isolating or shielding, it's been fairly challenging for them to follow the normal requirements of making a will. So the amendments intend to make it easier during this time, during when social distancing and isolating are quite normal occurrences. It's said to be almost an emergency response. And it's also aims to respond to and provide assurance, I suppose, to testators that have already been making wills using video witnessing methods between certain relevant dates, which I'll come on to address subsequently. So that's why the legislation has been introduced. What is interesting as well is how it's been introduced. So the basis of the order is the Electronic Communications Act 2000. And the explanatory memorandum indicates that that 2000 Act recognises that although previous legislation is not always drafted with modern technology in mind, and particularly those, for example, from the 19th century, where there's an opportunity for electronic communication to provide feasible alternatives to existing processes, and where that is not going to have an adverse effect, then those options should be available to users. And it's been implemented under Section 8 of the Electronic Communications Act 2000, and that allows ministers to modify existing legislation for the purpose of facilitating the use of electronic communications or electronic storage for a number of purposes. And that quote that I've just set out, that's at the start of the 2020 order, and it then sets out the new provisions. So let's come on to what new provisions have been introduced. The order itself is very short. There's only three provisions, and we're concerned mainly with paragraph 2. And that what the amendment has done is it's split the Section 9 of the Wills Act 1837 into 2 subsections. So the one that we discussed previously, that's going to be subsection 1. And then what's going to be inserted is a new subsection, which reads, for the purposes of paragraphs C and D of subsection 1, in relation to wills made on or after the 31st of January 2020 and on or before the 31st of January 2022, presence includes presence by means of video conference or other visual transmission. So that's the main provision. But what are some takeaway points? Well, first, the order is retrospective. It's got retrospective effect, so it applies from the 31st of January 2020. And The relevance of that date is that it's the first confirmed date of COVID-19 in England and Wales. And the retrospective effect is, I suppose, to carry out that purpose I mentioned earlier, to respond to the testators who have already made wills using electronic witnessing. The second main point is that it's going to run for 2 years until the 31st of January 2022. However, the matter is to be kept under review, and the government can either bring forward further legislation to extend or shorten the period if necessary. So it's worth keeping an eye on the time, because if it's introducing new possibilities to witness wills, if it shortens the time in which that's going to be available, then there needs to be an eye on that time. It also only applies to the subsection C and D that I highlighted in bold earlier. So that's the testator signing the will and the witnesses witnessing the will. What it doesn't apply to is if a testator directs someone else to sign the will on his or her behalf. So you can't have that remote direction. If anyone's signing on the testator's behalf, they have to be there with the testator. It also has a savings provision, which refers to the fact that nothing in the order will affect any grant of probate that's been made, or anything done pursuant to a grant of probate prior to the order coming into force. So that's the main substantive provisions. And obviously that it was in advance of that, there was the government guidance which has been available, and that set out quite a few, I suppose, suggestions in relation to how this is going to be done. So the first main point is that there's no specification of what video conferencing or what device needs to be used. What remains important to say to the witnesses is that there remains a clear line of sight. So the will maker and the witnesses, they can see each other signing the will, or they acknowledge their signature while showing it on camera. That's important. Another point that's important is that this whole process has to be live. The new legislation does not allow individuals to witness the will by watching a pre-recorded video. There's also a suggestion that the whole process, if possible, should be recorded and retained, and that's to, I suppose, assist the courts later in case there's any challenge, to give evidence that there's been valid execution, and also whether there's been any indications of undue influence, fraud, or lack of capacity. The guidance also proposes amendments to the drafting or amending of the attestation clause to show that video witnessing, virtual witnessing has occurred, and also perhaps to show where a recording is available. And finally, the government sets out a fairly detailed 5-stage process for signing and witnessing using video link. I don't intend to go through all of those stages, but I'll just flag up a few points. The first stage really concerns the will maker signing the will. So the will maker should ensure that the witnesses can see him or her, they can all see each other and their actions, that the process is recorded if possible, and then it provides guidance on what should be in shot of the video, that the will maker should hold up the will, the front page of the will, to the camera, and also then turn to the page they will be signing. Stage 2 deals with the witnesses confirming and acknowledging and understanding their role in witnessing the signing of the legal document. The suggestion or advice or guidance, I suppose, from the government is that if it's at all possible, then the 2 witnesses should be together, but obviously there'll be circumstances where that might not be possible, and if so, then they should be present, they should be connected via 2- or 3-way camera. Stage 3 is a little bit complicated, I think. It deals with the transfer from the will maker of the will to the witnesses, and I suppose in some circumstances this is going to cause problems. The guidance says ideally it must be done within 24 hours, and it must be the same document, but it recognises that there will be cases where a longer period is necessary, for example if the will is being posted. But the issue is that the will is fully validated when the whole process is complete. So the testators and both witnesses have signed it and either been witness signing it or have acknowledged the signatures. So there's obviously a risk that I'll come on to later in the time lag between the will being transferred to the witnesses. Stage 4 is about the witnesses signing the will, and stage 5 repeats stage 4 in relation to witnesses signing the will in case they're not together. So further guidance has also been provided by other bodies as well. So just looking at what are the potential risks in these new ways of witnessing wills. Well, first, clearly the video of the will is only going to pick up on a limited part of the room. It's not entirely impossible for someone to be out of shot and potentially exerting undue influence on the testator. There's technology issues, either with videoing or storing footage. I'm sure most people, I know I have, during this period, have experienced a technology issue, either sound, video, and there could certainly be problems going forward with recordings, for example, as well, running out of battery. Or if the recording is videoing someone in shot, but they're not actually the person signing, they're just the person who's somehow making noise, and so the camera's picking up on them. And there are also issues with storing the recording. So it may subsequently become lost, corrupted, damaged. And technology changes. So in the past, obviously, we had videotapes and floppy disks, which are fairly redundant now, and it's not impossible that in years to come, this technology that we use today could change. As I sort of referred to earlier, the stage 3 transfer of will could be quite problematic if there's a chance that the testator is going to die between that will being transferred to the witnesses. There's also, if it's been posted, there's opportunities for wills to be intercepted, to be lost in the post, or even to be seen by people. These are obviously confidential documents and can be seen by people they're not intended to. Again, there's also an issue if the testator is in fact isolating or shielding, and they can't go out to post a document or to transfer it, then they may have to rely on someone coming around to collect it. And if there is the possibility for someone else to come to them to collect the will, then it might be worth considering whether that person could actually witness the will from a distance under the actual requirements that the government have said would be possible, the scenarios that are possible. And clearly this is new, that there's more scope for challenge in the courts. So the guidance is very much that this should be a last resort, that where it's possible people should use the conventional way of witnessing wills. So we need to be sensitive to the risks. And finally, I just want to quickly recap on what hasn't changed. So there's no proposals at the moment, there's no change in relation to electronic signatures. The government has concerns about undue influence and fraud, so hasn't made any changes in that regard. As I've set out earlier, there's no remote signing on behalf of the testator, so if someone's signing on his or her behalf, they need to be there with them. And third, there's no counterpart documents. So it has to be the same document that the testator signs that goes to the witnesses. You can't send different documents, and this avoids the risk of different versions, people signing the wrong will, and just, again, the risk of challenge. So that's a very quick overview of the proposals, the guidance, the legislation. I'd be very interested to know what you think of this new legislation, and whether you think it's welcome, it's modernising, very historic act, or whether it's a missed opportunity and actually we need further proposals to accommodate electronic signatures, for example, or whether you actually think that this has gone too far and it's just going to lead to increased litigation. I'm going to end the slideshow and hopefully put up a poll. So looks like 59% for a trigger for future litigation, 35% for a welcome change, and 14% for a missed opportunity. So thank you all for listening to that talk. If you have any questions, please put them in the Q&A and I'll try and address them at the end. If you have any comments as well, please also put those in the Q&A, and I will hand over to Matt.
Well, fingers crossed there is more future litigation, because Emma Loizou's rates are very reasonable and she's now the expert on this topic. Emma has talked about making a will in the present climate, and I'm going to talk to you about the rest of the story, so actually administering estates. What I propose to do is focus on practical issues which have recently resurfaced for one reason or another. This may be because of a news article or a change in the law and procedure, or because of a recent case. And I'm going to group my tips around 3 topics: practical points about probate, key concerns about collecting assets, and actually administering estates. So let's turn to the first of those points, probate. My starting point is actually a relatively old story. Last October, Lloyds Bank realised that it actually had 9,000 original wills locked in a safe that it had forgotten about. Awkward. But this gave me inspiration for my first topic for today. What should you do if you think the deceased had a will, but you can't find it? Well, my main tip is to remember, where there's a will, there's a way. In particular, 9 ways, as I'm about to set out. So the first thing you should do, in my view, is simply ask the deceased's next of kin or family friends if they think the deceased had a will, and if so, where it is. Secondly, you should ask the deceased family to thoroughly search the deceased's paperwork for anything that references the will, or obviously is the will itself. So this could be, for example, a letter from a solicitor or a letter from a storage company. Thirdly, if the deceased had an attorney or a deputy appointed before they died, ask them. If you're not sure if there was a deputy or attorney, you can ask the friends and family, or possibly ask the deceased's local GP or their care home. Turning then to third-party sources, you could contact solicitors who you know have previously advised the deceased, or possibly their spouse. It's quite common for spouses to have their wills drafted at the same time by the same solicitors. So if you know that the deceased spouse will was drafted by, say, Smith & Jones LLP, go and ask them. Fourthly, if you want to be really thorough, you can ask other local solicitors in the area. Apparently, the Law Society offers a service where, for a small fee, it will email all of the registered solicitors in a local area and ask them to check their strong rooms for a particular will. Now, don't worry at this point if the firm of solicitors appears to have closed down or been shut down. The SRA should keep a record of what happened to the paperwork for that firm. Seventhly, you could consider contacting the deceased's banks, because even if they don't currently accept new wills, like Lloyds Bank, they might have quite a lot in a safe somewhere, whether or not they realise it. After that, you could consider contacting the local probate registry, because some people pay to have their wills stored there. Eighthly, you could use the website Certainty, which is the National Wills Register. It claims to have registered 50% of all of the wills executed in this country, so it's pretty good odds. And finally, you could advertise in the Wills and Whereabouts section of the London Gazette. Now, if all of this doesn't yield you anything, then in reality, you probably need to accept that the deceased died intestate. In fact, that's not uncommon at all. Statistics show that around 50% of people in this country just don't have a will. But let's say you do find the will. It's quite common for a will to list both lay executors and professional solicitors. But particularly for smaller estates, the lay executors might not be happy that the estate should bear the costs of the solicitor's time, and they may ask the solicitor to renounce. So what should you do if you are asked to renounce probate? It seems to me that there's no hard and fast rule here, but the Law Society has provided some helpful guidance. I've reproduced it in full on the slide, but I'll underline the 2 key points. Firstly, you're never required to renounce. But instead, when making your decision, you should consider firstly whether circumstances have changed since the time the will was executed, and whether the estate could easily be handled by a lay executor. Now, in my view, there's 3 other things you should consider as well. The likely size of the estate. Secondly, whether there are likely to be any claims against the estate. And thirdly, whether there's a need for an independent executor. For example, a lot of the time, you might be challenged by family members who just can't agree with each other because they hate each other's guts. And in circumstances where you know there's going to be ongoing litigation between lay executors, it might be sensible to retain an independent role to try and keep some control and steer on proceedings. But a final point to remember as well is, if you've already intermeddled in the estate, then you cannot renounce and you need to get a court order to remove you. All right then, you found the will and the named executors have managed to agree on who's going to secure probate. Now you need to make the application. In March this year, HMCTS introduced new application forms for grants for probate. And as always, they're snappily titled PA1P and PA1A. Now, on the one hand, these forms are significantly longer than the previous statement of truth-based applications that we had before. But on the other hand, HMCTS has confirmed that these new forms do not need to be sworn or witnessed, and you can sign them electronically, including typing your name. So overall, in my view, this is probably a positive development because that does make things quite a bit easier. In this context, I also thought I'd point out a recent consultation. Yesterday, the MOJ closed a consultation on whether it should be mandatory for probate practitioners to apply online for probate. In other words, they'll no longer be able to apply on paper. Now, keep an eye out for what the results are because it could affect you if you do like to make paper applications. In a similar vein, until the 30th of October, applications for certain non-contentious probate matters are now able to be signed by a statement of truth rather than sworn as an affidavit. This comes from guidance from the President of the Family Division of the High Court, Sir Andrew McFarlane. Now, I've reproduced the relevant part of the guidance in full on the slide. And what you'll see is at the end, he lists a long list of rules and sub-rules in the non-contentious probate rules and says for these, you don't need an affidavit. Now, some commentators online have suggested that this covers all non-contentious probate rules. But I'm going to be honest, I have not checked every single rule in that list, and I'm pretty sure the commentators online haven't either. So it's possible there are some that might not be included. So my advice to you is always check that the rule you want to rely on is in that list before you go making a statement of truth rather than an affidavit. A final point to bear in mind is paragraph 3 of the guidance confirms that the powers that be are considering making this a permanent change. So do keep an eye out in October when the current transition period comes to an end. All right, let's move on. As you know, Section 25A of the Administration of Estates Act 1925 states that a personal representative must collect and get in the deceased's assets. Unfortunately, long gone are the days where we all kept our money in physical currency stashed away somewhere. In fact, for many of us, gone are the days of even receiving hard copy bank statements. Many of us prefer to receive them by email or even just through an app. This can cause difficulties for executors. For example, in March this year, Direct Line conducted a survey of 100 probate practitioners and 2,000 lay members of the public. And this is the summary of the results. Around 88% of lawyers believe that digital banking makes it harder to identify and secure the deceased's assets. More specifically, in the last year, solicitor executors had found difficulties in nearly 30% of all of their cases. And turning to lay executors, 20% of spouses don't know where their other half keeps their assets. And 2/3 of children don't know where their parents keep their assets. So in short, there are real difficulties for both professional executors and lay executors when the deceased dies. And things are only likely to get more complex as younger generations switch to digital banking and the use of facial and fingerprint recognition to access information. Now that's quite a bit of doom and gloom for you there, but what can executors do if they can't quite find the deceased's assets? Well, I've got 7 more practical tips for you here. Firstly, you should ask the deceased's family members to thoroughly look through the deceased's paperwork for any relevant correspondence. Now, obviously, bank statements are ideal, but it could simply be circulars from a relevant bank to which the deceased might have been subscribed. So that will at least give you a starting point. Secondly, you can use the death notification service. This is a website which allows you to notify 22 financial institutions at once that the deceased has died. And if the deceased had an account with them, that financial institution must respond within 10 working days. Similarly, if you believe the deceased died with dormant accounts, i.e. accounts they hadn't used for several years, then you can use the My Lost Account website. This searches 70 financial institutions for dormant accounts that you might not otherwise have any evidence for. If you think the deceased had undiscovered pensions, you can use the government's pension tracing service or contact the Pensions Advisory Service by telephone or using that website. If you think the deceased might have had investment or insurance products, you can use Experian's Unclaimed Assets Register. This apparently lists £20 billion of unclaimed assets, and a search of that entire list only costs £25, so it might be a quick and easy way to check for a substantial windfall. Now, if you know the deceased was particularly keen on some kind of online service, for example, gambling, music, or cryptocurrency trading, as many pensioners are these days, you could consider contacting the relevant provider online to see if there's an account balance and to see what the policy of that website is on the death of the account holder. Sometimes, unfortunately, the credit just goes to the company. And finally, if the deceased ever lived abroad, for example, they went away for summers or winters, or simply moved there for a few years in their life, you could consider trying to undertake some of these steps abroad, although in reality, you'll probably need to enlist local help to do this. Sometimes, though, you'll encounter a different type of problem. You might know that the deceased owned a certain asset, but not be able to prove it. For example, you may know the deceased owned certain tradable assets, but not know where the documents of title are. This can cause problems if the executors want to transfer or sell those assets. An example of when this might be a problem is for shares. Now, if you're struggling to locate a title document for a known asset, the best thing you should do is contact the issuer for those title documents and ask for a new one. Now, be aware here, though, that an issuer is likely to require you to give some kind of indemnity, probably to confirm that the document is lost rather than simply transferred, and potentially indemnifying the issuer for any claims brought on the first document. Now, this is obviously not ideal for an executor to have to do. So that's why I emphasize in my previous slides the steps you can take to try and find assets in the first place. A second situation which might cause difficulty is where the deceased was a sole director and shareholder of a company. Where a sole director shareholder dies, the company is effectively left without any management. Fortunately, for most modern companies, this isn't a problem. The Articles of Association used for most companies from the 1st of October 2009 gives executors of the last living shareholder the right to appoint a director. However, older companies which relied on the Table A Articles of Association or bespoke Articles of Association that don't copy this provision will not allow executors to do this. Now, in either situation, what could a personal representative do? If there are no directors and no company secretary, there's nobody to add the executors to the list of members. And if there are no living members, nobody can appoint a director. And you end up in this circular situation where everything grinds to a halt. Fortunately, there's a way out. Section 125 of the Companies Act 2006 allows the court to rectify the register of members if there is an unnecessary delay in making a change. On a few occasions, the higher courts have used this section to help executors appoint directors for one-man companies. For example, in the King's Court Trust case, His Honour Judge Hodge QC held that the court could use this for a previous to 2009 company where the executors had applied for probate but not yet been given the grant. Similarly, in the recent case of Russell Price Farm Services, His Honour Judge Matthews confirmed that Section 125 can even be used where the personal representatives have not yet applied for probate. However, before he made this order, Judge Matthews required the executors to give undertakings, an undertaking not to renounce, an undertaking to apply for probate as soon as reasonably possible, and an undertaking to pay all the necessary taxes to secure the grant of probate. So this isn't a free pass, but it can be very helpful because if the court is willing to make an order, they can basically sidestep the problem and simply say the executors themselves are able to amend the register of shareholders. And then once you're on the register, you can appoint a director and the company can carry on trading. My final part of this talk is actually about administering estates once you've secured probate and collected the deceased's assets. Now, hopefully you have a bit more luck than the executors of the estate of James Brown. Brown died on Christmas Day 2006, and 14 years later, his executors and family are still bickering in the courts of South Carolina over who's entitled to what. Now, I can't tell you how to avoid acrimonious family disputes, and I'd kind of be doing myself out of a job if I did. But what I can do is give you some practical tips for ways to manage estates generally in the current climate. I'll cover 3 topics. As you know, the pandemic has caused all sorts of difficulties for lawyers and office holders who are just trying to do their duties. One unfortunate possibility is that an executor may contract coronavirus or fear that they've contracted it and need to self-isolate for a while and take a back seat from the administration process. This is even more likely potentially with older executors, for example, spouses or siblings of the deceased. Now, historically, at common law, person representatives are not allowed to delegate their duties unless the will allows it. So obviously the first thing you should do is check the terms of the will. Fortunately, many wills now incorporate the step standard or special conditions, both of which allow delegation pretty much in any circumstance. But if you can't rely on that, there are a couple of other things you can look to. There are a few old common law cases that provide exceptions to the basic no delegation rule. For example, the courts have allowed executors to delegate ministerial powers, that is, mechanical processes for implementing an existing decision. The courts have also allowed executors to delegate the management of land abroad to a local agent, for fairly obvious reasons. And thirdly, the courts have allowed executors to delegate powers where it's legally or morally necessary. Now, this rather vague phrase is from a very old case, and in my view, it's a little bit misleading. As far as I can tell, all of the cases that have relied on it really boil down to executors instructing either solicitors or bankers to undertake certain specific tasks, namely executing deeds, storing documents, or buying stocks. So actually, it's very narrow. Fortunately, though, these old historical cases are not particularly important anymore because there are 2 important statutory provisions you can rely on. The first is Section 25, the Trustee Act, 1925. This allows executors to delegate their duties by a power of attorney for up to 1 year. Now, this is a very useful provision, but don't forget that under Section 25, the executor still remains liable for the actions of the agent or delegate. So make sure you choose your person with care. The other option is Sections 11 to 27 of the Trustee Act 2000. This allows executors to delegate certain powers for an unlimited period of time to an agent, nominee, or custodian. However, there are 3 caveats to the recent act. Firstly, only administrative powers can be delegated, not dispositive powers. Now, in practice, what that means is if the decision concerns whether to distribute or how to distribute, you cannot delegate that. The second caveat is that although the executor can delegate to another executor, you cannot delegate to a beneficiary. And for small estates where executors are also beneficiaries, this can really limit the number of people who could be available for delegation. The third caveat is that throughout the delegation period, the executor must keep the arrangement under review and consider whether to intervene if necessary. Now, as long as the executor does this, they may be protected from liability, but it doesn't let the executor off the hook entirely. Now, to cut a long story short, any executor who's acting generally is able to delegate their functions under the terms of the will. But even if they're not, there's statutory provisions which can help them. And in my view, a delegation under the 25 Act is more likely to be useful because it's time limited and it requires a power of attorney and it's fairly simple. But you should always be aware of the other options and, of course, the risks. Another potential difficulty in administering estates is that the coronavirus can make it difficult or even impossible for executors to meet in person. Fortunately, though, in many, many cases, this just isn't going to be a problem. Many wills simply don't restrict the ways in which executors need to make their decisions. If there's no restriction and no positive requirement either way, then the general rule is that there's no formalities for making the decision. But many wills actually go further than this and explicitly give very wide powers to executors. For example, the step, standard provisions and special provisions expressly give an absolute discretion to executors in how they make their decisions. That's obviously a very broad term indeed. So if either of these apply to your case, then in reality, it'll be fine to take decisions by Zoom, phone, or even email exchange. However, some sophisticated wills and trusts require executors to meet. Now, if the word meet or meeting is used in your will, then you'll need to be aware of the decision of Bing and London Life Association. In that case, the Court of Appeal held that a meeting is a situation in which everyone can see and hear each other. So emails, texts, and in that case, a conference call does not count as a meeting. Some commentators have suggested that Bing is out of date or will be decided differently now, but in my view, the reality is it's the only authority we have. And the Charity Commission has expressly adopted it for its guidance to charitable trustees on meetings. So in reality, it's the only authority we have. Fortunately though, it's very easy, as we all know, to set up virtual meetings via Skype or Zoom or anything else. And very few people don't have access to a computer. But even in that tiny minority of cases where there's a requirement in the will to have a meeting and you cannot arrange a Skype call, it may still be possible for the executors later to ratify unanimously a decision that was taken not at a meeting. So for example, if you can only meet by telephone in the current climate, you could later try and ratify that in a virtual or in-person meeting, and that may still save the problem. So the takeaway from this slide really is, in almost all cases, there's nothing really to worry about if you cannot meet in person. My final topic of the webinar concerns claims against the estate. As you know, executors are under a duty to pay the deceased debts before distributing the assets to the beneficiaries. And in the vast majority of cases, the debts are clearly owed and easily quantified. For example, it's very easy to find out whether there's a mortgage and how much is outstanding. Sometimes, though, there's a risk that an estate might be subject to claims in the future. For example, if a professional worker dies before they retire, their estate may be subject to professional negligence cases for the last few years of the professional's life. And it can be difficult for lay executors to know whether there'll be such a claim, let alone how much those claims will be worth. And in those circumstances, it's important for the executors to take prompt and proper steps to try to ascertain any possible claims. Because if they don't and they get it wrong, in theory, they risk being held personally liable for the debts that they don't take into account. Fortunately, though, there's at least 4 routes open to executors to protect themselves. Firstly, executors can advertise for claims in the Gazette and any other appropriate newspapers. For example, if the executors are concerned about claims to do with a plot of land, you should advertise in the paper that covers the local area for that land. But remember, you must advertise promptly. In at least one old case, it was held that a delay of 5 months from death to advertisement was too slow. But if you follow section 27 carefully, then you should be protected from liability for those other debts. The second option is executors can apply to court for permission to distribute the assets on the condition that the executors take out insurance against future claims. Now, this is a relatively simple way of dealing with the matter, but do bear in mind that that obviously adds to the costs of the administration because you have to pay for and maintain the insurance, and that the executors are only protected as far as the insurance goes. Therefore, it may be better to turn to a third option, which is where you apply to court to distribute a certain portion of the assets, but retain a contingency fund to pay for future claims. I've put the 3 key cases on the slide there. But fourthly, and this is the reason I raised this point, if the facts are particularly novel or difficult, you can apply to court for basically bespoke directions to be told what you need to do to protect yourself. And the principles that the court will apply here were recently reviewed by Chief Master Marsh in the case of Rhys Studdert. Now, Michael Studdert was a Church of England curate and chaplain. He was also a convicted paedophile, and his executors were quite rightly worried about potential claims by his victims against the estate, although no one had yet come forward. So they applied to the court for directions on basically what to do. And Chief Master Marsh derived 4 key principles from the authorities. He said the starting point is that the executor's duty is not absolute. The duty is to take reasonable steps to ascertain and pay the deceased's debts. What counts as reasonable will depend on the facts of the case. But the more serious the claims are and the more likely they are to be brought, the more the court will expect the executors to do. So in that case, where the deceased was a convicted paedophile and they knew of at least one victim who was considering a claim, the executors were required to take quite extreme steps. However, ultimately, the court will balance, on the one hand, the need to pay the deceased's debts with the beneficiary's reasonable expectation that they should be paid. So in short, while it might be difficult to second guess whether, and if so, how much a claim will be brought for, there are several practical options open to beneficiaries and executors to try to protect the estate from future claims. With that practical tip, I'll end my webinar. Thank you very much. We'll now turn to the Q&A part of this webinar.
I think there's a couple in the Q&A box. So what do you think was the intention for the order being retrospectively applied to 31st of January? Surely no one will have had their will electronically witnessed prior to the announcement of the legislation, as that would not have been a valid testamentary document at the time. Thank you, Christopher. I think one of the purposes of the new order was actually to respond to wills that had been witnessed in this way since the 31st of January. So in the explanatory memorandum, the paragraph 7.3 says that the legislation will apply to all wills made on or after 31st of January. This means the provision will benefit testators who have already made wills using video witnessing under the conditions of the public health crisis. So I think it's proceeding on an assumption that there will have been people who haven't been able to have actual presence in these sort of particular times and have tried to do it in some other way. So it's responding to those challenges.
I've also seen a question for me from an anonymous attendee. Are you able to release the link to the guidance on signing the PA1P and PA1A electronically? Yes is the short answer. You'll get the slides afterwards, and that's why I always include hyperlinks to all of the things. The relevant slide will be slide 7, and the link takes you to a letter that's dated the 15th of April 2020 from the Probate Service Manager, and the particular part of the letter you want is on page 2. I'm not going to bother reading it out because you'll be able to download it and have it for yourself. But that's what you need to look out for. Yes, you'll have the slides, and yes, you'll be able to get the letter. Silence. If there is anything you think about after the fact, our email addresses will be on the slides that will be sent out to you. So please do get in touch with us. We're always happy to discuss any of the ideas we've raised. And if there's nothing further from you, it just remains for me and Emma to say thank you very much for listening. And we hope you'll tune in soon for another Radcliffe Chambers Junior Programme seminar. Thank you.
Thank you very much.